data inventarization according to GDPR. Can we have a presentation displayed? Thank you. Yeah, you can see the topic of our webinar right now. It's data inventarization according to GDPR. Today we will talk about several topics on this theme. The agenda of our webinar will be, first of all, the understanding of data flows of your company as the first step to GDPR compliance. Secondly, we will try to draw a data map. And thirdly, we will include some tips for data inventarization and understanding the applicable laws regarding the data inventarization. We will shortly introduce ourselves. My name is Vladyslav. I'm a privacy lawyer in Legal IT Group. We work on different projects regarding as GDPR and CCPA, other international data protection laws. And my colleague.
Yeah, hello. My name is Ihor Kotkov. I am also a privacy lawyer working for Legal IT Group. And today we will talk about data inventarization according to GDPR, about what Vladyslav has said before. Yeah, nice to meet you.
Yeah. And a short framework, we wanted to draw your attention to the war in Ukraine and our charity program developed by our company. Despite the difficult situation, which forced many of Ukrainians go to the war, and many of children move from their cities because of the shellings. We continue to work, and we provide consultations to our IT army, as well as take part in the information exchange to ensure that the children in need are supported regardless of their whereabouts in any way possible. And you can also help the children by donating according to our requisites, which you can find on our website in the charity page. Yeah, so thank you for your attention regarding this topic, and we will move to the topic of our webinar. I give the word to my colleague first of all.
Okay, thank you for supporting children again. And let's go back to the GDPR. Today we're going to talk about terms such as data inventory and data mapping, and how this connects with GDPR, namely GDPR principles, records of processing activities, third parties, fulfilling data subject requests, responding to security incidents, and so on. Firstly, we need to understand what the term data inventory or data mapping does mean within the GDPR or other applicable laws. These terms are synonyms. Very basically, personal data inventory or personal data map is a record of personal data processed by a company, which can be expressed in the variety of forms, such as lists, diagrams, tables, and so on. Overall, the process of data mapping helps companies to understand what information, including what personal data, the company collects, stores, or otherwise processes. Okay, that's clear. So we can talk about principles of the GDPR and connections to data inventory. The Article 6 of the GDPR sets out 6 principles that controllers and processors should follow when they process personal data in Europe. We would like to point out that supervisory authorities often impose fines on companies for violating GDPR principles. So you obviously have to pay special attention to those principles when you process personal data. And having a data inventory or having data mapping help you in complying with those principles. It means that you need to process personal data only with accordance with those principles. For example, GDPR provides with purpose limitation and storage limitation principles. And that means that you need to process personal data only for specified purposes and for no longer for which the data is used and for no longer that this data, for no longer than you need this data for these purposes. And creating a data inventory can help you identify all of these purposes and specify the exact time period for processing this personal data. And in this way, you minimize the risk that you will find out yourself in situation when you have in your database unnecessary data that stores for unlimited period of time, which is bad. And let's talk a little bit of records of processing activities. The data inventory and data mapping is closely related to the maintaining of records of processing activities, or ROPA. Maintaining of ROPA is a direct obligation for certain controllers and processors under Article 30 of the GDPR. We already said that you can make your data inventory or data mapping in a variety of forms, but the list of required information under maintaining the records of processing activities is strictly specified in Article 30. Such information shall include name and contact details of the processor, the applicable joint controller, controller representative, and DPO. Such information may also include the purposes of processing, description of the categories of data subjects and categories of personal data processed, information regarding international data transfers, storage period, and applied organizational and technical measures such as anonymization, VPN, access control, physical security, and so on and so on. It's really hard to identify and list all of such information, but if you have a data inventory or data map, it becomes much easier for you to complete this task. And also we should talk about third parties and their role in your data flow. The involvement of third parties has great importance nowadays because many companies use CRM systems, cloud technologies, other different marketing platforms, and so on. And because the personal data you collect may be shared with third parties, you need to include information about such sharing in your data flow map. Firstly, it is good to identify all third parties to whom you can transfer your personal data of your users. And then it is good to identify what personal data can be transmitted and for how long. Please also note that you may obtain such personal data not directly from data subject, but from other third parties. And when it happens, you should include information about such transmissions in your data flow map as well. And also, you should note that some personal data companies can obtain automatically, for example, through API or SDK, and such information shall be included in data flow maps as well. Also, we should talk a little bit about satisfying the rights of data subjects under GDPR. And maintaining of data inventory and data map also helps in such situations. And let's imagine a situation. You are owner of a platform which processes some personal data of users. And one day you obtain a DSR, data subject access request, from one of your users, and in this email, user asks you to provide them with all information you have on them. Firstly, you need to understand what information do you have about this person. You think and you remember that this user has an account on your platform, so you have a name, surname, and maybe a phone number. But at this time, you also remember that this user can provide feedback on your platform, and you can also collect some insights about users' behavior through cookies and other tracking technologies. And you also had a conversation with these users 2 months ago. So you have a lot of information about these users, and it's really hard to identify all of this information that you have without data mapping. But if you have data inventory or data mapping, I think it becomes more easier and for identifying all pieces of information. Yeah, and the last but not least, responding to security incidents. How does data mapping can help in such situations? Here, similar to satisfying data subject requests, data mapping can also help you to respond to such incidents. Of course, you need to have information security policies for handling such requests or personal data breach under GDPR, with strict rules how to react in a particular situation when security incidents is occurred. But if you have data inventory, you can more swiftly identify impacted data subjects in case of data breach. And under GDPR, there are notification timelines for notification of data subject, and for notification supervisory authority, and communication to data subjects. So the time saved can help you to meet these requirements under GDPR. I think that's all from me for this topic. And what you can go on.
Yeah, thank you. So I would like to talk about how to draw your first data map. As my colleague have already mentioned, data flow maps are one of the essential parts of the GDPR audit and ongoing GDPR compliance. Before we begin to draw, we need to understand what subjects take place in the processing activities of your company, namely from whom and what personal data you collect, and what are the third parties or service providers you share personal data with. And what roles do all of the subjects have under GDPR? It may be data controller or joint data controller, data processor, or data subject. If you want to simplify it in order to understand the basic concepts, data subject is the one whose data is collected for some purposes. Data controllers on his side defines the means and purposes of such collecting, so it uses personal data for its own goals. And if there are several data controllers and they define means and purposes together, that's the important point, that they do it together. They will be joint data controllers under GDPR. And data processor is the one who acts on behalf of data controller and processes personal data not in his or her own purposes, but in accordance with the purpose defined by the data controller. It may seem a bit abstract and unclear when we talk about it theoretically, so it's better to show an example. So let's imagine you have a software development company, and you need to draw your data map with regard to the services, to outsource services you provide to your clients. So take a look at this map. Firstly, you need to understand what are the sources from which you receive personal data. In this case, like on the map, you may see the following sources. Data collected from a visitor. Who is a visitor? We usually call an individual a visitor when he or she just merely browses the website and leave no personal data except some technical identifiers which are collected. Excuse me, do you hear me? Yeah, everything's fine. Okay, sorry. It may be, I'll begin. We usually call an individual visitor when he or she just merely browses the website and leave no personal data except some technical identifiers, which usually collected by cookies. It may be IP, GPS, country of visit, time of the site visit, duration of such visit, and etc. So the source of receiving such data is usually the website. Secondly, you may see potential clients. Who are these guys? These are the people who leave their personal data using, for example, contact us form on the website, or using email or phone number. These are usually the people who are interested in your services, and they leave their data for further communication regarding such services. And thirdly, let's imagine that your company is looking for more IT specialists. So you also use your website, email, and phone number to collect data about the potential employees. And such data is needed, of course, for communication with such employees. So as you may see, all of the data company collects as a data controller. It uses company in such processes is the data controller because it uses such data in its own purposes. For example, visitors' data may be used for analytics to understand users' behavior on the website. For example, from where are the majority of the users. And then potential clients' data for may be used for communication with such clients regarding the services, and employees' data for communication regarding the employment process. Then please take a look at the company's gray icon. So as you may see, the same company may act as a data controller and a data processor, but with regard to different processing activities. So in the case of typical software development companies, the most widespread situation is when client which asks for software development services is the data controller, and the company who performs such services is the data processor. Why is it so? Imagine your client has, for example, fitness software which collects some personal data from its users. Then this client asks you to develop a new feature for this software, providing you with access to the data this application collects. So client collects personal data from application users in its own purposes. Therefore, it is the data controller, as we have already discussed. And then it transfers such data to your software development company, which acts as a data processor because it uses such data only on behalf and in accordance with the order of the client. So your company does not define the means and purposes of the processing. Thus, you are the data processor in this case. And what happens with the collected data next? You can look above the company's icons. So such data may be transferred to different data recipients. They could be really, really different depending on the specifics of your service. We have identified most common use of service providers. These are the cloud storages, CRMs, and analytics services. The same story is about your contractors. We have defined them as the separate category because often companies attract contractors for accomplishing specific tasks. For example, it could be marketing specialists, technical specialists, lawyers, search engine analysts, and so on. They all will act as data processors because they process personal data only in accordance with your company's instructions inside the scope of provision of your services. What is also important, take a look at arrows which show what data are transferred during a particular processing activity. It may be important if you transfer, for example, only a particular category of data to one of the data recipients. For example, you use two cloud storages, one for clients' data and another one for visitors' data. Therefore, you need to make it clear on your map. Also, it's very important to see the destinations where you transfer your personal data. As under GDPR, there are additional rules concerning data transfers to so-called third countries. So the countries outside of the European Union and the European Economic Area. So it's better to understand what additional safeguards you need to implement to justify such transfer. For example, conclude a data protection agreement, which include standard contractual clauses developed by the European Commission. It's one of the GDPR requirements. So I guess that's all about the map. If you have any questions, you may ask, of course, and we will move forward to the topic of the tips for data inventarization and how to understand the applicable laws. And I'll give the word to my colleague.
Okay, thank you. The next topic is tips for data inventarization, understanding applicable laws, and we want to share with you some tips and tricks regarding data inventory and data mapping under applicable laws, namely GDPR. Firstly, it is important to understand which of the data you processed is personal. Personal data is any information relating to identified or identifiable nature of person. It can be not only name or surname, but email, IP address, nickname, date of birth, and so on and so on. And the most important is that such information can help to identify such a person. And you should note that not every piece of data is personal data. For example, anonymized data cannot be regarded as personal data under GDPR. And we have an example. Quite often, platforms, for any reasons, block their users and then anonymize their email used for creating an account on the platform and stored hashed email without storing actually personal data. And this solution kills two birds with one stone. You doesn't allow to create a new account on the platform, and at the same time you do not store any personal data because you store only hash, and this is good. Also, you should know about your roles under GDPR and about allocation of such roles. Honestly, it is not a simple task because allocation of roles under GDPR can be tough in most situations. But you should remember that the main two roles under GDPR is a controller or a processor. And controller is a company that determines the purposes and means of the processing of personal data, namely how and why personal data should be processed. And the processor is a company that processes personal data on behalf of the controller. We want to point out that the company that collects personal data can be both controller and processor. What has talked about this, but I want to give you an example. A processor can collect some personal data on behalf of a controller, and striking example of allocation of roles is the operation of payment processors, where the payment processor collects some personal data from users directly. And in this case, the payment processor who actually collects personal data will be a processor acting on behalf of their client controller, who even cannot have any payment data of users, but only reports of completed payments, for example. And we also advise you to utilize your data maps, data inventory, records of processing activities when you're working with data subject access requests. And we already looked at the case of data subject access request, but this also applies to handling with other requests as well. For example, when you handle with deletion requests, you can check in your data inventory and records of processing activities where and what personal data can be stored about this particular user. And by doing that, you can also understand whether you can satisfy this data subject requests at all. Because there is a situation that it may be situations that you may find out that you have other legal grounds for processing of such personal data, and you can find out that you have no information about this data subject, and you can receive these requests by mistake, and you cannot satisfy this request because you have no information about this user. It happens too. And I think that's all tips I wanted to share with you. So what?
I would like to address 3 more tips. I want you to pay attention to the necessity to specify the categories of data you collect. So depending on the service, depending of your platform, it could be different categories. For example, contact information is the most common case. This could be like email, phone number, full name, username in social medias, and so on. Message information is also common. It is all of the information which could be treated as personal data, which you receive during messaging, during communication with your clients. Financial information is used for example, issuing an invoice or other payment operations. When you have some paid services, you may collect also financial information about your users. And one of the most important and sensitive topics is the sensitive data, as if your service is connected, for example, with some medical services, medical issues, and you collect medical data, for example, from your clients, it is very important to identify that such type of data is being collected by you, because there are additional requirements to the collection of such data under GDPR. You need to obtain an explicit consent, for example, to collect such data lawfully. When you have specified the categories of the data you collect, it is very important to understand the retention periods of such data. So it may vary from different categories. For example, some technical data collected via cookies may be stored even like for a session or for a day, and other data, the contact information, may be used by a company like for several years, because you have the purpose of retargeting your previous clients with new features of your service, with new services. So you need to identify the retention periods for different categories of data, and if you cannot identify such periods for some reasons, you need to specify the criteria by which you delete or store some data. Also, these retention periods should be tracked in compliance with the storage limitation principle of GDPR, which obliges data controllers to store personal data only for the period for which such data is needed. So, for example, if you do not need any data, you shall delete it under GDPR. Also, purpose limitation principle GDPR is a bit similar. So you collect every piece of data, and you base such collection on the particular purpose. And for example, if you do not some amount of data for the particular purpose, for example, you collect a photo of your user for the communication purposes with him. It is not essential, so such data may not be used, and to comply with the purpose limitation principle, it is important to understand the limits of the data collection. And also, it's important to understand where is data stored. Some of the companies use their own services, servers, excuse me, and some companies use cloud storages. It's very popular now. And you need to understand where such cloud storages, for example, or servers located, because if they are outside of the European Union and European Economic Area, you need to implement additional safeguards to protect such data. Also, you need, moving to the next tip, also, I would advise you to perform a regular review of your data flow maps and records of processing activities, especially while you are implementing or removing some new features which make you to collect more personal data. For example, as we have discussed, the software development company with the data map, you decided to develop your IT courses, and you collect some data for the enrolling on such courses. You, for example, collect education data or certificates of English knowledge. So you have a new categories of data. You need to update your data maps and records of processing activities with regard to such new processing activities. And the last but not least tip for today, you need to understand the exact amount of information you need to maintain in accordance with Article 30 GDPR. I would recommend you to read, to examine this article, which says that controllers shall maintain a record of processing activities, but that record shall contain the information, the particular amount of information. So it's the name and the contact details of the controller, so of your company, for example, the purposes of processing, a description of categories of data subjects, and categories of personal data, the categories of recipients to whom the personal data have been or will be disclosed, and where applicable, information about the transfers of personal data to a third country, and general description of technical and organizational security measures. So I would like you to note that this article of GDPR asks only the categories of data subject, the categories of personal data, and the categories of recipients. So you do not need to disclose the particular piece of data, the particular data recipient, or the particular data subject. It could be only the category. So as we have discussed on the data map slide, it could be like visitors or clients. You do not need to say that John Smith's data you have collected and put that in your records of processing activities. So do not maintain unnecessary data, and do it in compliance with in accordance with the article of GDPR. I guess that's all we wanted to tell you today. We would like to thank you for your attention, and to ask you to subscribe to our YouTube channel for our new legal webinars, to track our updates on our social medias. And I would like to remind you one more time to donate if you have an opportunity to help the children of Ukraine. And Ihor?
Yes, thank you for attention. And I also would like to remind you that you can help Ukrainian children. You can find information about this on our charity page. The links, you can find the links in the chat or in the description of this webinar on YouTube, LinkedIn, Instagram, and Facebook. And I guess we can say goodbye. Yeah, thank you.
Thank you. Bye.